outstanding, and one Mr. Billings. They were calling just a second ago. So there are, I believe, 2 people I may still need to interview as well.
Okay, so I'd like to, and are there any positions that will also need breakouts too, either from the state or the defense?
I don't believe so at this point.
Not that I'm aware of, Your Honor.
Okay.
Judge, there may be 2 clients that I would ask for a breakout room just because there's some mental health issues that I'm not sure I would want live streamed, but we can do that in real time.
What positions were those? I like to do those first, especially since Katrina is alone.
Okay.
It's easier to do all the breakouts at once in the beginning.
Okay, so that's Jonathan Reeves, who is
position 15 needs a breakout.
Jonathan Steed.
So 15 and 18. Are there announcements at the jail before I begin regarding medical resets?
I don't think so, but the reset date for the state all-purpose calendar will be August the 18th.
All right, let's formally begin. Good afternoon, everyone. I'm Judge Melanie Williams. Today is Saturday, August the 6th. This is the state expedited accusations calendar. This calendar is for those individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. Today, we'll take matters of setting bonds. In rare cases, we may accept pleas. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding. All participants, this particular proceeding is being broadcast over the internet as a live stream, and it is also being recorded. That means that any member of the public can log on and watch this particular proceeding. At the jail, if possible, I'd like to go to the 2 breakout positions first, positions 15 and 18, and perhaps Mr. Howard can call the jail while that's happening and interview whoever else needs to be interviewed so that we can continue to move this forward and such that we're not here until, later than we need to be on a Saturday. So Ms. Jenks.
Position 18, medical. So give me about 10 minutes.
Is he going to be a medical reset, or do we expect him to be able to?
Yeah, he's located in medical.
Okay. And I also had a question about Mr. Darrell. I looked at the calendar earlier. I believe that I gave him a signature bond on Thursday. So I was curious as to why he appears on this calendar. Mr. Howard, please don't laugh. Does anyone have an explanation for why he's on this calendar?
He was released. He was rearrested, Judge.
You're kidding. Okay. Well, all right.
And Judge, I misspoke. I'm sorry. It's Mr. Sanders, not, I apologize, not Mr. Steed. It's position 17.
So 15 and 17 are
correct. I'm
positions?
sorry. Yes.
All right. We will go, if we could go to 15 and 17 first.
17 gonna be a behavior reset.
He's refusing to come? All right. So 17 will be reset. Ms. Jenks, had you previously spoken to Mr. Sanders at all? Had you interviewed him?
I did, Judge.
You did? All right. Not much we can do at the end of the calendar. Perhaps maybe we can discuss some options. All right, let's actually get started. Can we do 15 first and go into a breakout?
Yes, who all that needs to be in the breakout room?
Jonathan Reeves also in medical as well.
Okay, so we can't do any of the breakout positions first.
Yeah, everybody else in courtroom 3.
And I'm sorry, can I just inquire, is that since the time I spoke to them?
I think they're located in medical. That's the location.
Medical is just not on the screen yet.
It's not on the screen.
Okay. So that's not Mr. Reeves is not a reset.
No,
it's just, what'll happen is what'll happen is it just will go slower. Despite my best efforts to move this calendar today. All right, can Mr. Howard still give the jail a call, and we'll take whatever position does not belong to Mr. Howard.
All right.
Okay, we can do position 14, round 2. Come on.
I can't hear over there. I'm not even on the bench, but I'm not even, I'm sitting in the chair.
All right. Please come quickly.
Yeah, he said, no, he said he's right there. Where?
All right, good afternoon, Mr. Ramsey. Your case is 22 CR. I'm sorry. Okay. Happy Saturday, everyone. This case is 22 CR 005238C, in which you are charged with theft by receiving stolen property with the offense date of August the 5th. Do you understand your constitutional rights? You do? All right, I believe you're nodding. Ms. Harrison, I know that you put some recommendations to my other phone. Would you mind sending them to the other chat so I can have them after you give me this history? What is the history for this defendant? I'm on the Zoom conference twice. I apologize, Ms. Harrison. I keep my phone on here in case we have an interruption of service such that the calendar is not delayed. So after you give me this history, if you would type it into my other so I can look at it on here on the screen. What is this defendant's history?
Second arrest. First arrest was January 2014 for driving without a valid license. That was a conviction in Troup County, Georgia. And he is recommended UJR pretrial, nothing further.
All right, thank you. Whose case is this for the state? Oh, Ms. Backus, you're muted. It's good to see you.
Good to see you as well. I'm with you now.
All right, state's recommendation.
The state's recommendation for this case, give me 1 second, trying to pull up this other document. The state's recommendation on this case is there's already a $3,500 surety bond in place. And we're asking for that to remain in place in addition to no alcohol, drugs, or weapons. Your Honor, this incident is actually a continuing incident beginning on July 15th and ending with the defendant's arrest on yesterday, August 5th, 2022. An officer was patrolling Highway 74 when alerted to a stolen Georgia vehicle tag number T087964 on the Highway 74 camera. When the officer ran the tag number, it returned stolen out of Cobb County from July 15th. The officer located the vehicle parked at the racetrack gas station, which is located at 7845 Sonoya Road in Fairburn. The officer then pulled behind the vehicle and activated his emergency lights. He then got out of the vehicle and approached the driver's side to find it was unoccupied. However, a witness at the racetrack advised that a black male with short hair, yellow shirt, and gave the full description. He said that the defendant exited the vehicle and ran across the street. The officer went across the street and advised, and someone over there advised that a male fitting the description had run inside the hotel. So then once he got inside the hotel, they said he had left and gone to the BP truck stop. And that's where the defendant was located and detained. Your Honor, a day prior to this incident on August 4th, officers responded to 2575 Whitehaven Drive in reference to a stolen vehicle report. At the location, the officers met with Mr. Kenneth Goodrich, who stated he rents out his personal vehicles to people via an app called Hire Car. And he had rented the defendant a car through the app for only 2 days. He got it on July 14th and was supposed to return it on the 16th. On July 15th, the defendant he communicated via the app, said there was mechanical issues, and so Mr. Goodrich left a vehicle on July 15th for him to pick up. And so he left a 2008 Ford Crown Victoria in the parking lot, and the vehicle was retrieved on that day. He didn't charge him to switch out the vehicle, but he was supposed to be returning that vehicle that next day. The victim tried to contact the defendant multiple times, but he was never able to get in contact with him via the app, and he didn't report it until August 4th because he said he was trying to give the defendant a chance to return the vehicle. Based on this defendant has 13 cycles. He has, and Your Honor, I'm sorry, this was a busy day, and I wasn't able to call the Superior Court. However, he has this case on this day, which is the vehicle, but then I'm assuming that once they did the inventory, he then has the subsequent charges, because on the same day, he's got 3 counts of trafficking, 2 counts receipt of a firearm by a felon, obstruction, 6 counts possession of a Schedule 1 or Schedule 2 controlled, 2 counts possession of Schedule 3, 4, or 5 controlled, possession and distribution of marijuana, 2 counts possession of firearm by a felon. And so this is on that same day. And so that's my assumption. Based on this, Your Honor, we do feel that the $3,500 surety bond is appropriate to remain in place. Nothing.
Right,
What
Thank
position
you.
are we doing?
we're on position 14.
Right, I'm only showing 2 cycles.
Right, this is a second arrest. It's Felipe Ramsey.
That is
It's a-
not what I have. Give me 1 second.
And also,
Let's
there's
check.
no other hold here, so I'm not clear on where the state is getting that information.
Yep, give me 1 second.
Let's clarify quickly.
Okay.
Did he also go to felony? Maybe, is that why?
No,
No, okay.
So I am showing. He also has, based on the GCIC, it looks like there are multiple aliases. And that may be what it is, but I do show that this is, let's see.
I'm only showing 2 cycles and no aliases.
Ms. Backus, that's not what you're seeing?
This may,
No, I'm not.
this may be the wrong GCIC, but it is under his account in Odyssey.
Okay.
So I don't have the correct GCIC.
All right, we'll defer to the GCIC as given to us by pretrial services. Ms. Jenks, we'll go to you. Ms. Backus, do you want to amend your recommendation in light of the fact that we're going to accept the GCIC as given to us by pretrial?
Yes, but can I reserve that until after the state or after the defense?
You can, but I'm sure Ms. Jenks is going to ask for a signature bond, so I doubt that there's much else that will need to be considered. So,
And in light
but
of the new information, Your Honor, I just want to clarify with my supervisor. That's why I want to
yeah,
wait.
okay, that's fine. We'll let Ms. Jenks give her argument, which I'm sure is signature. And then we'll come back to you, Ms. Backus. Go ahead, Ms.
Thank
Jenks.
you. Thank you.
Judge, you're 100% correct. We're asking you to follow the recommendation of pretrial. He's been approved. We're asking for a signature bond through pretrial. Mr. Ramsey has completed high school, Judge. He does live with his cousin here in Georgia. He's provided that information. He's got a 15-year-old daughter that he helps to support financially. I do think that first of all, I think the charge is incorrect. I think maybe it's an alleged theft by conversion. I don't believe that the charge that they charged him with is correct information, but nonetheless, that's to be argued at a later time in division. We, again, Judge, are asking for a signature bond through pretrial. He's got no violent history, or really no history at all outside of that one driving with invalid license.
Okay, thank you, Ms. Jenks. Ms. Backus, is that giving you enough time?
Your Honor, the state will just, will leave the recommendation as is and you can make your ruling.
Okay, I just wanted to clarify that. Mr. Ramsey is going to receive a $5,000 signature bond through the jail. Through pretrial services. I apologize. Through pretrial. And he is to have no weapons, drugs, or alcohol as a condition of that signature bond through pretrial services.
Thank you, Judge.
Thank you, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Position 21, White.
24?
Yes.
All right. Good afternoon, Mr. White. Your case number is 22 CR. 005234E. I want you charged with 1 count of battery with the offense date of August the 4th of 2022. Do you understand the constitutional rights that I just explained?
Yes, ma'am.
All right, thank you. Ms. Harrison, I see he's
Excellent.
recommended. Is this his first?
No, he has 5 cycles. Last arrest was June of 2021. For battery family violence, he completed diversion and it was dismissed. He has 2 DUI, 2013 and 2015 misdemeanor convictions.
Okay, thank you. Ms. Francis, always good to see you. It's been a while. What's the state's recommendation?
Yes, Judge. The state is recommending a 5,000 surety bond, a stay away from the 3 locations. I'm sorry, stay away from 10865 Indian Village Drive. That's Johns Creek. No further contact with Wona. I don't want to butcher this surname, Judge. I'll just spell. The first name is Wona and the surname is Kogout. Also stay away from Lisa, Lesa, last name Karafotius, Karafotis, and also stay away from Miss Merkins, Merckens, anger management, and no drugs.
Excuse me, ma'am, I think you're reading the wrong case. The inmate said that's not him.
Are you Tony White?
I am Tony White.
But it's
Okay,
position 21, not position 10.
we're on position 21, Ms. Francis, is that correct?
I am on position 21, Judge.
Okay, let's proceed, I guess. Let's hear the facts of the case and then we can have the defendant give us a very brief yes or no whether or not this is him. This
Yes,
has been an
Judge.
interesting day so far. All right, go ahead.
Yes, Judge. So in this case, Judge, the defendant kicked the victim in her ribs, and while she was being attacked, 2 of her friends, the 2 other parties that I just listed their names, tried to intervene, and they were assaulted as well. This defendant has 6 cycles, which, as pretrial told you, involved another battery, which the defendant did, I think, diversion for, and yet we're here today on a similar charge, Judge. Additionally, Judge, based on the information that we received, we are concerned for victim intimidation because both parties lived together. And we're also concerned for the safety of the victim based on the facts that were alleged in this accusation. We're also considering, Judge, to add 2 additional battery charges based on the fact that the other 2 females that were assisting the victim were injured based on the officer's report.
Okay, Ms. Jenks, was that your understanding of what took place as far as, I know your client seems to have some concerns, but I want to see if this was what you discussed with him?
I mean, partially what the state said is contained in the arrest affidavit, Judge. I think they took some poetic license to elaborate a little more than what even the officer put in the narrative, frankly. Judge, we're asking you to consider a signature bond, and if you're not willing to do that, we're asking for a much lower bond than 5,000. For Mr. White, that would be quite high. He does not live with the alleged victim in this case, Judge. He lives at the address, which I believe is on his jail screen, which is the 444 Highway 101 North. He's been living there for 10 years with his family. He does have a job, Judge. He did finish high school. He works in fiber optic installations for the past 3 years with Next Tier's Infrastructure Solutions. My understanding, Judge, is that the 3 alleged victims that Ms. Francis spoke about actually had been drinking. I think at worst, this is some kind of mutual combatant type of situation. In fact, Mr. White spoke to me, and because we're only seeing each other at this point, obviously, if I was in person in the courtroom at the jail, I would be able to see what he says he has, which are visible bruises on his back and around his torso from these 3 women attacking him. So for all those reasons, Judge, again, we're asking you to consider a signature bond. In this case, he has no problem staying away from the location where those 3 women are. And having that stay away order put in place as well with respect to those 3 people. But we are asking you to consider that.
All right, thank you. At this time, the defendant's going to receive a $2,000 surety bond He is to stay away from the alleged victim. I mean, he's to stay away from the address on, I believe it was Indian Village. Was that correct, Ms. Francis?
Not according to the warrant. I don't see that address. The address belongs to position number 10. that she read.
What's the address, Ms. Francis? You're muted.
One moment, Judge. Let me confirm.
According to the arrest affidavit, Judge, it's 757 Hill Pine Drive Northeast. That's where the call came out of.
Yes, Judge, it's 757 Hill Pine Drive. My mistake,
Okay.
Northeast.
Okay, he must stay away from that address and have no further contact with the alleged victims and have no alcohol, drugs, or weapons. As a condition of this bond, he will be reset to the SAP calendar on August 18th, whereby this case can be revisited at that time. Anything further?
Not from the defense, Judge.
All right, hearing none. Best of luck to you, Mr. White. Can we go to the next position, please?
I'm sorry.
16, read.
All right, good afternoon. Are you Dominique Reed?
Excuse me?
Are you Dominique Reed?
Yes, ma'am.
Put your mask back on. Thank you. Your case number is 22 CR 005240F, in which you're charged with criminal trespass with the offense date of August the 5th of 2022. Do you understand your constitutional rights?
No,
You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. Do you understand that?
I hear you.
All right, well, I'm informing you of your rights and taking notice of the fact that you have been so informed. Ms. Harrison, can I have his history, please?
26 cycles. Last arrest, July of this year, probation violation. Underlying charge is a non-fingerprintable charge in DeKalb County. Record does indicate an open case pending for theft by possession of stolen mail, theft by taking, misdemeanor, and loitering in Portland, 20 CP 207444 in Fulton County. He was granted a signature bond through pretrial. Pretrial is surrendering that bond. Additional open case for burglary in the second degree and obstruction of law enforcement officers, 21 CP 203516.
Excuse me.
Additional open case, disorderly conduct.
Yes, sir. I'm not trying to.
Don't say anything, Mr. Reed.
Why not? I don't understand what's going on.
Please, hold 1 second. Proceed, Ms. Harrison.
Possession and use of drug-related objects. Possession of methamphetamine, 21 CP 201513. Additional open case, forgery in the second degree, forgery in the first degree, 20 CP 194904. Additional open case, financial transaction card theft, 2 counts, identity theft fraud when using or possessing identifying information, 21 CP 200070. Record also indicate open probation for theft by receiving stolen property. Case number is 1090287, sentenced October of 2014 with
I
12
think,
months.
Yeah, I think I've got it, Ms. Harrison. That's
Okay.
very thorough. Thank you. I appreciate that. Ms. Backus?
Yes, Your Honor. Hopefully all of this information is correct. This incident occurred on yesterday, August 5th. An officer responded to a suspicious person call at 893 Stonecrest Road Northeast. Upon approach, the officer spoke with the victim, Mr. Andrew Ryan. 2 witnesses, John Mitchell and Sarah Mitchell, advised Mr. Ryan that they were outside attempting to get in their car when they saw a male walk past their vehicle. And the male, who's later identified as the defendant, asked Mr. Mitchell if he lived at the incident location. Mr. Mitchell told him that he did not live there. And then Mr. Mitchell saw the defendant walk around the home towards the back. Then he walked back towards the front, and he walked inside the garage of the home. At that moment, Mr. Mitchell called the homeowner, the victim, Mr. Ryan, and told him that there was a random man inside of his home. And then Mr. Mitchell walked inside of the house to attempt to warn Mr. Ryan. Mr. Ryan was upstairs on the phone, and he came downstairs to meet Mr. and Mrs. Mitchell in the kitchen. And then they heard rumbling in the bathroom, but the victim said that he was at home by himself. So as they walked back towards the stairs, they saw the defendant standing at the top of the stairs walking down. And Mr. Ryan asked the defendant, "Why are you in my home? How did you get in?" And Mr. Ryan also noted that his black headphones were around the defendant's neck, and the defendant tried to run out of the house, but Mr. Ryan grabbed him and told him he had to wait until the police arrived. Your Honor, you've heard the history from 2019 alone. We have 1, 2, 3, 4, 5, 6, 7, 8, 9, over 10 charges, some that are very serious. And so the state is asking for a there's a $3,000 surety bond in place. We're asking for that to remain in place, stay away from that incident location, no further contact with Andre Ryan, and no alcohol, drugs, or weapon while out on bond.
Thank you. I understand that Mr. Reed has some concerns. He's waving his hands. I'm going to go to you, Ms. Jenks, and hopefully by the end of your presentation, we will have resolved any questions that your client has.
Judge, we're asking you for a $1,000 good bond on this case, considering his history. I mean, he was actually, and you'll see on his jail screen that he was at the Salvation Army Adult Center prior to this arrest for criminal trespass. He does say that he is able to live with his mother. He did provide her name and address and phone number for me. But, you know, based on his history, we're asking for a $1,000 good bond.
Mr. Reed, I need you to calm down. I need you to calm down and listen to what's ever being told to you at the jail. Mr. Reed, can you unmute him, please? Mr. Reed, what is your concern?
My concern is this man standing next to me. Ain't nobody doing nothing, like all this stuff going on behind me, okay? So these two, so what happened? What else happened in the house? Why is that not recorded when I talk to
Okay,
officers?
we're not talking about.
Wait, you're not letting me say what happened. No, you let the
I'm
judge
not-
talk. I'm trying to tell you what happened in the house. The man jumped on me and nearly died twice. They almost suffocated me twice. I'm talking about I could barely breathe twice trying to leave the place. I told the cop that, and nobody want to hear this.
Okay. Ms. Reed, I don't want you to say
that. I'm talking about some stuff, some headphones getting took.
Mr. Reed, you have a right to remain silent. You're saying things that may end up being used against you.
The biggest problem did the man pick up the headphones.
Hey, can you mute that, please, Deputy?
Yeah,
please.
What I'm saying though,
Thanks.
Mr. Reed, what I was trying to explain to you is the things that you're saying will end up being used against you. I was trying to protect you from your own self-incrimination, which is one of the constitutional rights guaranteed to you. All right. At this time, you're going to receive a $2,000 surety bond. You are to have no further contact with Mr. Ryan, and you must absolutely stay away from that location on Stonecrest Road. You are to have no alcohol, drugs, or weapons as a condition of that surety bond, and you are to comply with what the deputies in that courtroom are telling you. You understand that? All right, that will conclude his case. If you want to say something about the bond, that's the only thing I will hear. Unmute him very quickly. You can unmute him at courtroom 3. Mr. Reed, calm down. Oh, well, all right. Yeah, okay. All right. I do not believe we have a Spanish interpreter today. Let's address that concern and that issue. I know we're gonna need one. I think we're gonna have to reset that case if we.
I'm working on it with Mr. Jordan, who's is not on the premises right now with me, but he's working on it. So I haven't heard back from him. So if you give us a little bit of time, we may be able to address it at the end of the calendar.
Okay.
And Judge, if there's a chance we're gonna get an interpreter, I'd rather.
Well, if you know anything about me, if there's a chance we'll get it done, I will do it.
Thank you.
I was told, okay, there was.
But we will just see. All right, who do we have next?
Position 5, he had a problem turning in the courtroom.
Okay. And counsel, please enter your appearance before I begin.
Yes, Your Honor. I've not done it in writing. I was just hired a short time ago. My name is Stephen Shoemaker, Georgia Bar 987512.
Okay,
How are you
Mr.
this
Schu-
morning or this afternoon?
I'm well. I believe you might be GSU alum. Are you, Mr. Shoemaker?
Yes, I think we were there at the same time.
We were there together. Good to see you, Mr. Shoemaker. All
I
right.
hope I made it good. I hope I made a good impression.
All right, let's begin. Are you Mr. Dayton Depping?
Yeah.
Okay, Mr. Depping, your case number is 22 CR 005227A, in which you're charged with one count of willful obstruction of a law enforcement officer with the offense date of August the 5th of 2022. Do you understand your constitutional rights as I explained at the beginning of the calendar?
You gotta say that.
I need, yes, all right, thank you. Ms. Harrison?
No prior history, Judge.
All right, thank you. Ms. Francis?
Yes, Judge. The state is recommending a 3,500 surety bond relying just on the facts of the case. In this case, Judge, the defendant lunged at the officer and physically pushed him while he was detaining another subject. So for these reasons, the state is asking for a 3,500 surety.
No conditions, Ms. Francis?
No drugs,
No.
alcohol, weapons.
No, if you didn't have any, that's okay. I was just curious. All right.
Just
Mr.
no
Schu-
drugs, alcohol, or weapons while on bond.
All right, Mr. Shoemaker?
Can you hear me okay through this mask, Judge?
I can.
Okay, I'm just a little self-conscious about it, but if you can hear me, I'm going to ask you for a signature bond, and I'm going to explain why, if I may have a moment.
Yes,
Uh,
very briefly,
I
though. We
certainly
have a
don't
long
intend
calendar
to-
today. Go ahead.
I'll be brief. I have somewhere else to be as well today. I certainly don't intend to try the case here today, but Mr. Depping was at a concert outside last night when he witnessed Atlanta PD handcuff a man who was not resisting. He and several people saw the police slam approximately 6 foot tall man who was not resisting to the ground, to the point that you could hear his head smack the pavement. I am not speculating. I have that evidence. What happened to that individual and what will happen to that officer is yet to be seen. And I'll be happy to send the video to anybody who's on this Zoom who wants to see it, because I'll be sending it to Keith Gamage in the morning. There are 5 witnesses who I will depose about this. I can hear them saying, "Oh my God, this man didn't assault the officer. He walked up to him, did put hands up and say, 'You need to stop this.' And the officers then arrested him." My client has no criminal history. He's been married for 2 years. He has a 1-year-old at home. His wife is pregnant. He is employed full-time. One of those 5 witnesses and his employer, Miss Cindy Hudson, stand up, Cindy, is here from Florida. Okay. And my client also has he's self-employed and works for Miss Hudson. So he has 2 businesses. All the factors, Your Honor, the victim and the witness are the Atlanta PD who arrested him. He's not a threat to anybody. He has no priors. He is not a threat to the community. He is not a threat to commit felonies. He was interceding in what I can witness with my own eyes as an act of police brutality. And I'll send that to anybody who wants to see it. I have captured that evidence, and I'm going to be talking to Keith Gamage about it early next week, personally. So I'm asking for a signature bond for this man, because if you saw this on the news, you would gasp.
All right, based on the information before me, the defendant's going to receive a $500 signature bond through the jail. I believe that there's nothing further to add from either party. All right.
That's it, Your Honor. Oh, I'm sorry, Judge. I do need to be clear. My client lives in Pompano, Florida. He will have to report to pretrial services, but he does intend to return home to his family in Pompano. He's not a flight risk. He hired me. He's going to reappear here anytime.
All right, my ruling will stand. It'll still be through the jail.
Thank
Ms.
you.
Ms. McCutcheon, you're saying something. You're
You're
muted.
muted.
It's good to see you.
Good afternoon, Judge. Good to see you too.
Yes.
Counsel, if you would, when you email that evidence to Mr. Gamage, would you also copy myself? You can send it as soon as it's possible for you to send it. I'd like to review it as well. And that's
What is your email? How do I get you? What's your email address, man?
Michelle.McCutcheon. My name's on the screen at fultoncountyga1word.gov. I'll also put
Okay,
it
I'm
in the chat.
writing it down and trying to keep going. Michelle.McCutcheon at what?
Fulton
Fulton
County GA, Fulton County
Okay.
GA, one word, .gov. Yes.
All right,
All right.
I will
Thank you.
happily do that.
Thank you.
And
All
Your
right.
Honor, I don't think I did as well as the guy before me. That was a hard act to follow.
I think you did just fine, Mr. Shoemaker. You take care. Have a good day. And best of luck to you. Can be excused. Best of luck to your client.
Thank you very much. May I speak with him in the back real quick?
All
Thank you,
right.
Your Honor.
Take care. All right, who do we have next?
Position number 5, Collins.
I'm sorry, position number what?
5.
5. That's not a position. Oh, Mr. Howard, you're back. Have you been able to interview everybody?
That everyone that desired to be interviewed, yes, Judge. Mr. Billings didn't appear to want.
Oh,
to be
there's some
interviewed.
people who
Yes.
did not wish to have your services today, Mr. Howard.
Yeah, I think Mr. Billings indicated he wanted to be reset, is what I was told.
Okay.
He wouldn't.
I'm sorry, Judge, did she say position 5? Because position 5 was the gentleman that just.
Right,
left.
we just did position 5. Who's
Right, I'm
performing?
sorry. She is position number 3, I think. Yes, 3.
Are you Miss Collins?
Yes, ma'am.
Okay, good afternoon, Miss Collins. Your case is 22 CR 005255B, in which you're charged with battery family violence with the offense date of December the 13th of 2021. Do you understand your constitutional rights?
Yes, ma'am.
All right, thank you. Ms. Harrison?
Second arrest. First arrest was December of 2019 for theft by shoplifting in Forsyth County, Georgia. She completed PTI and the case was dismissed. Nothing further.
Thank you, Ms. Harrison. Ms. Francis?
Yes, Judge, the state is recommending a $3,000 surety bond, a stay away from 325 Park Avenue, apartment 2. No further contact with the victim, Catherine Hossam, that's Catherine with a K, and Hossam, HOSSOM, anger management class, and no drugs, alcohol, or weapons while on bond. Judge, this case involved parties that were roommates. The two parties, defendant and victim, were roommates and supposedly best friends. They both got into an argument regarding intimate details between both of them and the victim's boyfriend. And during this argument, the defendant allegedly rammed the victim's head into a metal pole, causing visible injuries. Judge, the factors alleged are egregious because shoving someone's head in a pole could result in serious, if not deadly injuries. So for these reasons, Judge, we're asking for the bond that was recommended, the $3,000 surety bond.
All right, thank you. Mr. Howard?
Yes, Judge. Ms. Collins is 20 years old. She is a lifelong Georgia resident. She was born and raised here. She is currently in her 3rd year at Georgia State University she's studying physics and astronomy. She also works full-time, so she's very conscientious for Barkfield Animal Hospital in Cumming, Georgia. She's been on that job for about 7 months as a receptionist. And Judge, I will point out that this is an allegation from December 13th of 2021. It's been several months have passed since this allegation. And in fact, Ms. Collins was unaware that there was a warrant or even an outstanding issue as it relates to this. She indicated that after the event, one of the detectives contacted her, but they at no point indicated that she was being charged or that she needed to turn herself in. Had she known, she certainly would have handled it immediately. I believe her family member is at the jail and may even be in the gallery in support of her. So she certainly has ties to the community, Judge. The facts are in dispute, Judge. Ms. Collins tells me that in fact, the other party was the aggressor in this case because of mistaken belief that she was involved with her boyfriend. She also tells me there was another witness on the scene who left with her out of fear of safety, as well as ring camera video footage and other factors that'll be relevant when it comes time to contest the merits of the charges. But for purposes of bond, Judge, we would just argue that she has significant ties to the community. She doesn't have any failure to appears or probation violations in her history. She lives at 1445 Loblollow Lane. That's where her parents live. She's lived there since this incident. She will continue residing there. So we would ask the court to consider a signature bond through pretrial or through the jail in this instance.
All right, at this time, defendant will receive a $3,000 signature bond through pretrial services. She is to have no further contact with the alleged victim. I believe last name was Qassam.
Yes.
Was that correct? And she is to stay away from the incident location on Park Lane, I believe I wrote. And to have no alcohol, drugs, or weapons as a condition of that signature bond through pretrial services.
All right, thank you, Judge.
Best of luck to you, Ms. Collins. All right, who do we have next?
Position 7.
Okay, Candace Goolsby. Ms. Goolsby, your case is 22 CR 005229Y, in which their charge is theft by shoplifting with the offense date of August the 4th of 2022. Do you understand your constitutional rights?
I do.
All right. Ms. Harrison,
26 cycles, last arrest January of this year, failure to appear in Fulton County. Underlying charge is theft by shoplifting. Record indicates an open case pending for theft by deception, 2 counts, identity fraud, 5 counts, 22 SC 181059. Additional open case for false statement, identity fraud, and forgery in the 1st degree, 22 SC 180873. Record indicates 2 violations of probation, 5 failure to appear within the past 10 years. 2019 misdemeanor conviction for theft by shoplifting. 2018 3 separate conviction misdemeanor for theft by shoplifting. Nothing further to add.
thank you. Ms. Francis,
Yes, Judge, the state is recommending an increase, an increase in defendant's surety bond from 1,000 to 5,000. Stay away from all Walmarts, no contact with the employees, a theft class, no drugs, alcohol, or weapons while on bond. Judge, this defendant passed all points of sale at the Walmart with items in her cart totaling $193.89. She was stopped by their loss prevention.
I'm sorry, Ms. Francis, go ahead.
She was stopped by their loss prevention officer as a result and detained. She has 27 cycles, which include multiple theft charges. She has 2 theft convictions in her cycle. I counted over 12 theft charges on her cycle, so she does pose a significantly high risk of reoffending. She has multiple failure to appears and possibly will not show up for court when required to do so. So for these reasons, Judge, the state is making the recommendation of 5,000 surety.
All right, thank you. Mr. Howard?
Yes, Judge, Ms. Goolsby is 38 years old. She is a lifelong Georgia resident, a graduate of Douglas High School. She currently works full-time at Wendy's as a cashier, and she's certainly concerned about losing that job. It's been a difficult time for her financially, so she's certainly concerned about being able to return. She does support a daughter who's 18 years old, who lives with her, and she's been living at the Larchmont Circle address for the past 4 years. And she understands that if, she would need to return to court at a later time to address these charges. Judge, we would ask the court to allow the bond to remain set at 1,000. Of course, Ms. Goolsby would like the court to consider releasing her on a signature bond, but I did discuss in live the issue that may not be possible. So I would ask the court to at least leave it at 1,000. She would be required to post a monetary bond to ensure that she will return to court, but it wouldn't so burden her potentially so that she remains in jail indefinitely on a non-violent offense, Judge. So we'd ask the court to consider either signature bond or remaining at 1,000 good.
All right, her bond will remain as set. She does need to stay away from all Walmarts. I don't know if we can do the no further contact with all What was the incident location? Which Walmart was it?
Howell Mill Road, Judge.
Okay, I'm just gonna do the stay away from all Walmarts. I don't think it's possible for me to issue a no further contact with all Walmart employees wherever they may be. I think that might be.
It was just for that location, Judge.
Even still, I'm not sure how we would do that, Ms. Francis. I'm sure that's over 100 people. So we'll say she must stay away from all Walmarts and have no alcohol, drugs, or weapons as a condition of that bond.
Thank you, Judge.
All right. Best of luck to you, Ms. Goolsby.
What's that reset date? I'm sorry.
I'm sorry.
What's
Say
the
that again?
reset date for SAP? I apologize.
She will be reset to the SAP calendar. All those who receive a surety or cash bond today will be reset to the August 18th SAP calendar. I believe I'm presiding that day, but this case will be revisited at that time.
That's
Thank you,
the bond amount?
1,000 is staying at set.
Okay.
All right. Who do we have next?
Petition number 2, Brewer.
All right. Good afternoon, Mr. Brewer. Your case number is 22
It's coming now. Good afternoon, Your Honor.
Can you hear me?
Yes, ma'am.
I believe the screen might be, okay, there it is. In which you're charged with theft by taking with the offense date of June the 28th of 2021. Do you understand your constitutional rights?
Yes, ma'am.
All right, verifying with Ms. Francis, this is the correct offense date. And
I
Ms. Harrison, can I have the history too while she's
I have
looking
June
at it?
28, Judge.
Of 2021?
Yes, Judge.
Okay, wanted to clarify that. Ms. Harrison, the history, please.
12 cycles with history in Georgia, Ohio, and North Carolina. Last arrest, December of 2020 for criminal trespass and false imprisonment. That is an open case, 21 CR 03382 in Clayton County. Record indicates 2 failure to appear within the past 10 years and a 2019 driving while license suspended misdemeanor conviction. Nothing further to add.
All right, thank you. Ms. Francis?
Yes, Judge. The state recommends a $5,000 surety bond. I'm sorry, the state recommends that the $5,000 surety bond that is set remain as is. Stay away from Hobnob Restaurant. The location is 245 18th Street Northwest. Theft class, no contact. Disregard, Judge. No drugs, alcohol, or weapons while on bond. Judge, this incident occurred at the Hobnob Restaurant where the defendant showed up there and told them he was there for a delivery pickup. He walked into the cooler room and removed from there 3 cases of steak and 2 packs of hamburgers and left the location. Judge, he is a multi-state offender. He has history out of 3 states, as pretrial noted, North Carolina, Ohio, and Georgia, and is a flight risk. He also has previous theft offenses on his cycle and poses a risk of reoffending. Additionally, Judge, he has multiple FTAs for cases where he was required to show up and never did. So for these reasons, the state recommend that the bond remain as set.
It's currently set at 5,000? Or is that the state's recommending an increase? You're muted.
1 second, Judge.
Okay.
It appears to currently be set at 5,000, Judge.
It is currently set at
Yes.
5,000?
Yes.
Okay. All right, Mr. Howard?
Yes, Judge. Mr. Brewer is 37 years old. He has lived here in Georgia for more than 30 years. We're a transient society, so he's traveled to other states, but his residence has been here. He's a graduate of Southwest DeKalb High School, right in DeKalb County. He works full-time in the state of Georgia, the city of Atlanta, for Geodis Warehouse. He's a forklift driver for that company, which has been really good for him financially. He's been on that job for only 2 weeks. And prior to that, he was a box truck driver for a family-owned business. And as has been brought up at one point, he was working for Hobnob Atlanta. And Judge, I will note that Mr. Brewer tells me that the alleged victim, in this case Hobnob, when he was working there, above and beyond the deliveries or above and beyond the inventory that they ordered for the location, that it was pattern and practice for the general manager as a perk of employment that they would allow them to purchase meat from the wholesaler at a discount. He indicates in this case that is exactly what had happened, is that he had prepaid for those items, which is why he showed up there. He indicates that he gave me the names of the general manager and other people that we can contact who will be able to speak to the fact that those items had in fact been paid for and that they were on the video with him. There was not a situation where he went into a cooler and snuck out with meat. So we believe at a later time, we'll be able to establish that he in fact did not commit the act that he's been charged with. We would ask the court to take into account the fact that, we did hear about the history and the prior arrest. However, after he completed his probation on the offense that he was arrested for and released in 2013, he's only had one other arrest, and that case is currently pending, which means he has no conviction since he was released on the earlier case from 2013. Judge, given that this is a more than a year-old allegation, he was unaware of it, was on his way to work when he, this warrant popped up, or else he certainly would have wanted to resolve it or handle it prior to now. He had no idea that this was even an issue. So we would ask the court to take the nature of the charge into account and allow Mr. Brewer to sign his own bond in this case. He certainly intends on returning to court now that he is aware of this incident to answer the charges.
All right, thank you. At this time, Mr. Brewer is going to receive a $1,500 surety bond. He is to stay away from that Hobnob location so long, unless his employment requires it, and to have no alcohol, drugs, or weapons as a condition.
All right. Thank you, Judge.
All right, best of luck to you, Mr. Brewer. Who do we have next?
Field team, medical.
Oh, we're going to medical. This is the one where we're requesting a breakout. Let me,
Yes, Judge.
Judge, this is Ms. Lewis. I have an update. We will not have a Spanish interpreter available for today.
all right, so the position that required interpretation will be reset to the SCA calendar on Monday.
What position is that?
I'm not sure that I know. Ms. Jenks, what position required interpretation?
Position number 13 on the calendar.
Yep.
Okay, so 13 will be reset for an interpreter for Monday's SCA.
That will be the 15th.
All right. All right. Good afternoon. Are you Jonathan Reeves?
Yes, ma'am.
Okay, Mr. Reeves, your case is 22 CR 005239C, in which you're charged with 1 count of simple battery and 1 count of battery, each with the offense date of August the 5th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney today, and Ms. Jenks is available to represent you. This proceeding is being broadcast over the internet as a live stream, and it is also being recorded. That means any member of the public can log on and watch this. Do you understand your rights, Mr. Reeves?
No.
Okay, thank you. Now, can I be placed in that breakout? I believe it'll be me, Ms. Jenks, Ms. Backus, I'm sure Ms. McCutcheon as well. And if Mr. Howard wants to observe, I don't have any objection to that either.
So fine, Ms. Jenks will be fine.
He doesn't need
I'm
to.
fine.
All right.
I apologize, Judge. I thought my video was on. I was nodding my head in affirmation of your instructions.
Today is rough.
Yes.
It really is
Yes.
for a Saturday. I was doing my best to move us
Yes.
along.
I don't think they pulled me.
I'm sorry, I'll get you.
All right, at this time, the defendant is going to receive a $2,500 surety bond, broken down 1,000, count 1, 1,500, count 2. He must have no further contact with the victims in this case, and he is to stay away from the address of the incident location. Will you put that back on the record for me, Ms. Backus? I don't have that address. I think it was on Revere Drive, but I want to
Yes,
confirm
Your
that
Honor.
address.
The,
All right.
The incident location is 3445 Revere Drive Southwest.
Okay, perfect. And he is to have no alcohol, drugs, or weapons. For now, he will be reset to the SAP on August the 18th. We've discussed other referrals in the breakout. Hopefully those will take place.
Excuse
Thank
me,
you, Judge.
this is Katrina.
Yes,
I can join the breakout room due to I'm hosting and I didn't want the recording in there. I need to know the name of the victims.
Ms. Backus, we put those on the record, please.
All right, the victims' names are Charles Arnold and Jesse Lewis.
I saw that you had a question, Mr. Reeves. The best thing for you to do is to speak to Ms. Jenks. But if you have a very limited question, please don't say anything. I don't want you to interfere with your constitutional rights. What is your question?
Address is 3445 Revere Road, not Drive, and the other victim is my brother, Jesse Reeves.
Okay. Okay.
This report does say Lewis.
I didn't make that correction.
I'm sorry. I believe so. Why don't we put both addresses out of abundance of caution?
No, I'm just talking about it does has road on the information, but I'm just saying the name. He said his name is brother is Jesse Reed instead of Jesse Lewis.
Middle name is Lewis. His
Oh, okay, I got you.
And Judge, I'm sorry, one other issue, just because his father's name is also Jesse Reeves. Sir, Mr. Reeves, Jonathan, is your dad a senior? Is it Jesse Reeves Senior?
Junior. My brother's the third.
Okay.
So your father is a junior?
Yes.
Okay, so Judge, if you can just make that clear, because if he is able to bond out and he does go to his father, I just want to make sure
Right.
that there's not, confusion.
So so everybody's on the same wave. It's Jesse Reeves the third. That is the no further contact. That's correct. That's the brother, correct? Jesse Reeves the third, not.
Yes, that's correct.
Thank you.
All right. Have we clarified the victims' names? All right. Best of luck to you, Mr. Reeves. Who do we have next?
Position 4, Mr. Cooper.
Okay, good afternoon, Mr. Cooper. Your case number is 22 CR 005226G, in which you're charged with 1 count of battery family violence with the offense date of August the 5th of 2022. Do you understand your constitutional rights?
Yes, ma'am. How you doing, y'all?
All right, good afternoon. How are you? Ms. Harrison?
22 cycles, last arrest, November of 2016 for possession of marijuana less than an ounce in Clayton County. Record indicates a 2015, 2 separate misdemeanor conviction for possession of marijuana less than an ounce, a 2010 forgery in the 1st degree out of Clayton, 1 violation of probation within the past 10 years, nothing further to add.
All right, thank you. Ms. Francis?
Yes, Judge. I'm sorry, Judge. Ms. Harrison, can you tell me what the total cycles was?
22.
Okay, just want to make sure I have. Yes, Judge, the state is recommending a $3,500 surety bond. No further contact with Joyce Jenkins, that's Joyce, Jenkins, Jenkins, a stay away from 360 Thomasville Boulevard, Southeast, Atlanta, anger management class, and no drugs, alcohol, or weapons while on bond. Judge, officers responded to a dispute call at this location, and the victim advised the officers that her boyfriend, who is the defendant, grabbed her and tossed her about the apartment. Officers did observe scratches on the victim's arms and on the victim's back. Judge, this defendant has over 23 cycles was what I got from my history, which includes several battery charges as well as several FTAs, which makes this defendant both likely to reoffend and likely not to show up for court. And based on the relationship between the parties, Judge, the state is concerned for the safety of the victim, so we're recommending the $3,500 surety bond for these reasons.
I'm sorry, what was that stay away location? I did not get it, Ms. Francis.
360 Thomasville Boulevard Southeast.
Okay, thank you. Mr. Howard? You're muted.
Yes, Judge, thank you. Mr. Cooper is 54 years old. He too is a lifelong Georgia resident. Oddly enough, he attended my high school, which no longer exists, but he works full-time for MF Green and Sons as a truck driver. He's been on that job for 7 years. He certainly has every intention of returning to court to answer these charges. Mr. Cooper tells me that on this particular date that Ms. Jenkins was actually the one who was the aggressor, that she had been drinking. She came into the room and began to argue with him and threw water on him, bleach on him, and told him to get out of the house, and became physically aggressive towards him. He indicated at one point he attempted to restrain her. So if she suffered any type of visible injury or any thing that could be seen, he believes that would be why. But he also tells me that he has injuries that were not observed or the officer didn't inquire about or no one would have known about that he shared with me. So we believe that she was actually the aggressor in this case, Judge. I didn't hear any recent history of violence. I think a 2016 arrest was the last thing that I heard. I didn't hear failure to appears in his history. He certainly intends to return to court to address this matter. I believe he's recommended through pretrial services from the report that I received this morning for signature bond. So we would ask the court to allow him to sign his own bond. He certainly can stay away from that 360 Thomasville address. He lives at 1132 Grace Drive in Forest Park. His father lives there. When he's not on the road driving, that's where he lives. So it's no problem staying away from that address. So we would ask the court to consider a signature bond.
Thank you. At this time, Mr. Cooper is going to receive a $2,000 surety bond. He is to have no further contact with Joyce Jenkins and stay away from the address on Thomasville Boulevard. He is to have no weapons, drugs, or alcohol as a condition of that surety bond. And he will also be reset to the SAP calendar on August 18th.
Thank you, Judge.
All right. Thank you. Best of luck to you, sir. Who do we have next?
Position number 12, Paris.
All right, Mr. Paris. Okay, Mr. Paris, your case is 22 CR 005236E, in which you're charged with criminal trespass, theft by shoplifting, and of willful obstruction of a law enforcement officer, each with the offense date of August the 5th of 2022. Do you understand your constitutional rights? Do you understand your rights, Mr. Paris?
Not exactly, but
You have a right. I believe you understand your rights. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney today. Do you understand that, Mr. Paris?
I forgot to eat some.
Okay.
I think that's a mistake.
Okay. Do you think you understand what I'm saying here today?
I'm sure I can.
Okay. All right. We're going to set your bond today, Mr. Paris. We've spoken previously. I believe you understand how this works. All right. Ms. Harrison, can I have the history, please?
40 Cycles, last arrest, January of this year for failure to appear in Fulton County. Underlying charge is criminal trespass. Record does indicate an open case pending for aggravated stalking in DeKalb for case number 21 CR 2245. Additional open case, theft by shoplifting 18 CR 008118E. Record indicates a 2019 criminal trespass conviction, 2019 violation of family violence order, 2018 trespass, 2012 theft by shoplifting. Nothing further to add.
Thank you, Ms. Harrison. Ms. Backus?
Yes, Your Honor. For this case, there's already a $2,000 surety bond on each, for a total of a $6,000 surety bond. The state will recommend a reduction to 1K on each surety bond, a stay away from the incident location, and a theft class. This incident occurred on August 5th. Officers responded to a criminal trespass call upon arrival. The officer spoke with a Miss India Withers. She stated that the defendant was trespassing at the Shell gas station at 902 Donnelly Howell Parkway in Atlanta. She said that the defendant took items from the store and placed them in his bag. She asked him to vacate the premises several times, but he refused. The officer then asked the defendant to take the items that he took out of his bag and exit the store. And the defendant replied by saying that he was not giving the items back because someone told him to go to the nearest store and take what he wanted because he was hungry. And the officer explained to the defendant that things don't work like that and he had to pay for the items he took. He still refused to give them back. The officer then told the defendant to turn around and attempt to detain him. And the defendant told the officer he was going to have to kill him before that. And he resisted by walking away. When the officer tried to take his wrist and handcuff him, he then took a fighting stance. And the officer had to pull out his taser and try to stun the defendant, which was unsuccessful. But subsequently, he was able to grab the defendant and get him handcuffed. Your Honor, you heard the history. We do feel that the surety bonds are necessary. He does have a recent FDA, so we have, of course, concerns about him returning to court. But just in 2019 forward, 1, 2, 3, 4, 5, 6, 7, 8, and 9 charges in the last couple of years, many of which are criminal trespass orders and violating a family order. And so the state does feel as though the surety bonds and the stay away and the theft class are appropriate. Nothing further, Your Honor.
Thank you. Ms. Jenks.
Thank you, Judge. I mean, essentially, Judge, for Mr. Paris, any bond amount is tantamount to no bond for him. He's not working right now. We're asking you to consider a signature bond through the jail, but if you are not inclined, we're asking for $500, a good bond on each charge. And has to be reset to state or purpose.
All right, I'm gonna accept the defense's recommendation. He'll receive $500 on each charge for a total of $1,500. I am also gonna order a BHET in this case. And he is to have no alcohol, drugs, or weapons should he make bond. Anything further?
Nothing further. Your Honor, did you put the stay away on the?
Oh, yes, he must stay away, but I'm essentially sure he will not. Stay away from Donald Lee Hollowell Parkway. All right, anything further?
No, Judge.
Further, Your Honor, thank you.
All right, best of luck to you, Mr. Paris.
SK position 15.
Position 15.
18, 1-8.
Oh, 1-8. Is this the case we're requesting a breakout as well, Ms. Jenks? You're muted.
One moment, Judge. No, we do not need a breakout room.
Do not need a breakout. Okay.
Not for this one. Thank you.
All right. Good afternoon, Mr. Jonathan Speed. My name is Melanie Williams. This case is 22 CR 005242J, in which you're charged with 1 count of criminal trespass and 1 count of obstruction with the offense date of August the 5th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of this case can and will be used against you. You also have the right to an attorney at this proceeding. This proceeding is being broadcast over the internet. It's also being live streamed. That means any member of the public can log on and watch this. Do you understand your rights?
Yes, ma'am.
All right, thank you. Ms. Harrison?
21 cycles with history in South Carolina, North Carolina, Florida, and Illinois. Last arrest, April of 2018 for public misconduct in New York City. Record indicates a 2014 misdemeanor conviction for possession of controlled substance in South Carolina, 2010 theft, felony conviction out of Illinois, North Carolina, 2009 breaking and entering motor vehicle. Nothing further to add.
All right, thank you so much. Ms. Backus.
Yes, Your Honor. This incident took place on yesterday. An officer was approached by a Greyhound security officer, Imari Cosby, who stated that there was a passenger refusing to leave the terminal after being told to do so. Upon arrival inside the bus depot, the officer observed a white male who was yelling, "I'm not going anywhere until the police come." The officer then told the defendant, "I am the police and you need to leave." Defendant began to comply with the instructions, but then stopped and stated he wasn't going anywhere. And the defendant laid on the floor yelling, "Take me to jail." The officer told him he wasn't trying to take him to jail and he was free to leave, but he still refused to leave. And eventually he was arrested, Your Honor. Based on the history, Your Honor, and based on the fact that he has significant history in other states, we do have concerns about him returning to court, Your Honor. So for on count one, we are asking for $1,000 surety bond, a stay away from the incident location, no alcohol, drugs, or weapon, and on count two, a $500 signature bond for a $1,500 split bond. Nothing further, Your Honor.
All right, thank you. Ms. Jenks?
Yes, thank you, Judge. Mr. Steed is a 48-year-old male. He grew up in Illinois. He is currently living in North Carolina. My understanding, Judge, is that he had a paid ticket on his way to Fort Lauderdale when this incident happened here in Atlanta. My understanding is that Mr. Steed got sick on the bus. The bus driver asked him to leave, and then some version of what was announced in the citation occurred. We're asking you to consider a signature bond. I don't think I heard any failure to appears in his history. I know he's got some multi-state cycles that pretrial said, but was there an FTA? I may have missed it.
None was indicated.
Right. So he doesn't have a failure to appear in his history, Judge. It seems like he will show up to court. For those reasons, we are asking you to consider a signature bond in the same amounts that the state asked for.
All right, at this time, Mr. Steed will receive a $1,500 signature bond through the jail, 1,000 count one, 500 count two. Was there a stay away requested by the state? I don't believe so. I'm not sure the stay away would be
Yes,
appropriate here.
there was a stay away from the incident location, which is the Greyhound station at 232 Forsyth Street in Atlanta.
All right.
I mean, Judge, sorry, excuse me.
I'm
just wondering if you'd be willing.
Yeah, he needs to go probably, he doesn't live here, so he'll probably need to get on that bus station to go back home.
Mega bus.
So, all right, I'm not gonna order the stay away.
Thank you.
This time. All right. Anything further from either the state or the defense at this time?
No, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position 19, Ms. Stone.
Okay, Ms. Stone, your case number is 22 CR 004243F, and what you're charged with reckless conduct with the offense date of August the 5th. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Harrison.
6 cycles, last arrest February of 2020 for driving offense. No disposition listed. Record indicates 1 failure to appear, a 2015 reckless conduct in which she pled nolo, and a 2020 possession of marijuana less than an ounce, also a nolo plea. Nothing further.
All right, thank you. Ms. Backus?
Yes, Your Honor, this incident occurred on yesterday. An officer responded to 3154 Hickman Drive Northwest in Atlanta in regards to a dispute with a weapon call. Upon arrival, the security officer, Mr. Miles Sham, stated that he was in his vehicle and he heard roughly 5 shots. When driving to the area, he stated that he saw a dark blue vehicle leaving the scene. Thereafter, a female, later identified as the defendant, approached and said that there was an altercation and she fired 2 shots at the vehicle. Mr. Sham at that time detained her and placed her in his vehicle. He did read her Miranda rights, but she stated that she wanted to make a statement. And then everything subsequent is what she told the security officer. She expressed that the argument started between her and her son's father, Markel Knox. over her daughter having a play date with another child. The defendant did not like the idea, and the argument continued to escalate. She then stated she exited the vehicle and went into her apartment. And Mr. Knox followed her inside. That's where the argument continued. And the defendant stated once she realized the argument, I'm sorry, one second. Okay, so once she realized that the argument wasn't going to calm down, she left the apartment. He followed her out there as well. Then she went back inside, and he followed her there. So then he pushed her in, or she pushed him in the face with an open hand. I'm sorry, these facts are a little,
Let's start again, Ms. Backus. Let's start it with the shot. I got confused after. Let's start again.
All right, so this is what is being said after the Miranda rights are read. She's then conveying the story. So the defendant was read the rights, and then she stated that she wanted to make a statement. She expressed that the argument started between her and her son's father, Mr. Markel Knox. That's the victim in this case. And they were arguing over their child having a play date. The defendant said that Mr. Knox did not like the idea, and the argument escalated. She then stated that she exited the vehicle and went into her apartment, and Mr. Knox followed her inside where the argument was still ongoing. The defendant stated once she realized the argument was not going to calm down, she went outside. The defendant and Mr. Knox followed her out there as well. Then she went back inside of the apartment. Once inside of the apartment, she stated that Mr. Knox pushed her in her face with an open hand and continued the argument. When that happened, the defendant's brother, Mr. DeMarcus Stone, intervened and attempted to break the two up. The defendant went into the back room, and Mr. Knox followed her again, and the argument continued. And then the defendant said Mr. Knox struck her with his closed fist to the left side of her face. Then Mr. Knox left the room, and at that time, she heard the children screaming. And when the defendant walked into the living room, she saw Mr. Knox was on top of her brother, striking him with a closed fist. And that's when she went back into her room, got the firearm, and came back to the living room and told Mr. Knox, "You need to go." And so Mr. Knox did get off of her brother and ran out the house and attempted to get into her vehicle. And that's when he began to back up, and she yelled, "Get out of the car, it's not your car." And Mr. Knox continued to back up. And that's when she said she fired the two shots in the direction of the vehicle in an attempt to strike the tires out. Your Honor, was that a little bit more?
Yeah, I think we've got it. Okay.
Okay. And so essentially what she's saying is she was assaulted, her brother was assaulted, and so she pulls out the gun to shoot. Your Honor, I guess the seriousness of this situation with pointing a gun at anyone, of course, we have concerns about that. She does have an FTA as well. And so there is concern about it as recent as 2020. And she also has that 2015 reckless conduct charge. And here we are again in 2022 with the same charge, Your Honor. And so the state is asking for a $5,000 surety bond, no further contact with Markel Knox, a third-party transfer of the child, a stay away from the incident location if that's their shared residence and the victim is still there, 1 day anger awareness, and no alcohol, drugs, or weapon. Nothing further.
Okay. Thank you. Ms. James, can you clarify that for me? The question I have now is, do they still live together? To your knowledge?
They have never lived together. That apartment is her apartment. That car is her car. So Ms. Stone, I mean, what the statements that Ms. Stone stated to the officer is identical to what she said to me with some added detail, Judge. And that is that the dispute that started everything was actually related to her eldest child. She's got 4 children, Judge, a 12, 10, 7, and 1-year-old. The youngest, the 1-year-old, is the only child who is the biological child of the alleged victim, Mr. Knox, in this case. The playdate dispute that the state talked about from the arrest affidavit was actually related to the 12-year-old child who Mr. Knox is not the biological father of. And he engaged in an argument and tantrum related to his views about this play date that was going to happen, that Ms. Stone thought was a healthy play date with a with a friend that she was looking forward to having the two girls become friends through that play date. From everything that happened in this case, Judge, actually, Ms. Stone was trying to move away from Mr. Knox, and he would not get away from her. They had been in the vehicle together. She asked her kids to leave and go to a neighbor's house because Mr. Knox was already arguing and screaming and tantruming about his perspective and views of this play date, where again, he had no standing to even suggest anything. She went into her apartment to get away from him. He followed her into the apartment. She saw that it was getting more and more contentious. He was getting violent with her. She left the apartment. He followed her out. And then he proceeded to engage in violence against her and her brother, and then was about to drive her car away. So we're not disputing that any kind of, incident with a weapon is not serious, but she actually took several steps to try to get away from Mr. Knox before things escalated to the point that they did. And he would not leave her alone. The brother tried to intervene. He started hitting him. He would not leave him alone. And that vehicle is her vehicle, Judge. Solely her vehicle, is not a shared vehicle. So for all of those reasons, Judge, we are asking you to consider a signature bond. She does have the sole custody of those 4 children. They are with her father right now. The apartment that is in her name that she's been at for 2 years is that one that's the address is on the jail screen, Judge. She has her own business selling clothes and hair accessories online, Judge. But she has also been doing some online work as a co-host for an Airbnb. And she needs to be out so that she can help support her children, Judge. For all of those reasons, we are asking you to allow a signature bond through pretrial. And if you want to step up the level of oversight from pretrial, that would be fine.
Your Honor, the state strongly objects to a signature bond at the end.
I think I've got it.
Okay, thank you.
I think it's clear. We don't need to revisit. I think it's clear. I am going to sound for the victim though at this time, because I just saw someone who does not like a county employee join. If Markel Knox is present and would like to be heard, this is your opportunity to do so. All right, hearing none. Defendant will receive a $2,000 surety bond. She is to have no further contact with the alleged victim, in this case, last name Knox. She is to have no weapons, drugs, or alcohol. She can arrange transport of her child through a third party. And I believe that will conclude all relevant matters as it pertains to this case. Is there anything further from either the state or the defense?
Judge,
Sorry, go ahead.
Go ahead. I just want to make sure that. All right, good.
All right, let's go with Ms. Jenks first. Ms. Jenks first, and then
go ahead, Ms. Jenks.
I just want to make sure that the third-party transfer is related to that 1-year-old child, Judge. Yes. He is not the biological father of the other 3 children.
Third-party transfer of the child with whom they share.
Okay.
Yes, so just to clarify, Your Honor, $2,000 surety bond, no further contact, third-party transfer, no alcohol, drugs, or weapon. Was there any additional condition?
No, I did not just stay away because it appears that is her home, correct?
Correct.
Is that incorrect? Okay.
That's correct, Judge.
Okay, so let's,
thank you, Your Honor.
I don't believe a stay away would be appropriate then.
Sounds good. Thank you.
All right, who do we have next?
Position 17.
Okay, hold one moment. Small technology issue.
What position is that?
17.
All right. We are back in business. All right. Are you Bruce Sanders?
I am, Your Honor.
All right, Mr. Sanders, your case is 22 CR 004241Y, in which you're charged with 2 counts of criminal trespass with the offense date of August the 5th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding. This proceeding is being broadcast over the internet as a live stream, and it's also being recorded. Do you understand your rights, Mr. Sanders?
I do, Your Honor. Thank you.
All right, thank you. Ms. Harrison.
8 cycles, last arrest, July of this year, for forgery, 1st degree in East Point, Georgia. That is an open case, 22 CP 210370. He received a signature bond through pretrial. Pretrial is surrendering that bond. Record also indicates an additional open probation in Clayton County for terroristic threats and acts. 21 CR 07417, sentenced October of 2021, 60 days confinement and 12 months probation. One violation of probation, one failure to appear within the past 10 years. Nothing further to add.
All right, thank you.
Judge, this was the case where we needed a breakout.
I was gonna ask if this.
Yeah, I thought it was
breakout.
reset behavior earlier. I guess I misread that.
Yeah, that's what I thought as well.
All right, can we please be placed in a breakout?
This is, I'm sorry, Judge, what position we just started talking about?
We're on 17.
17, and y'all need a breakout room, okay.
Yes, please.
Okay, give me a second. Y'all should be able to invite yourself back in the breakout room y'all were just in. Y'all see it on your screen to go into a breakout room?
No.
Just click on it and it should, y'all should be able to all go back in there. Do anybody do not see it, or do I need to close out that room and put everybody back in another one? Miss Jinx is in there, so, all right, I'll just move you out to another room.
Hold on, I got it.
Oh, no, I'm gonna, I just started moving everybody. Okay. I'm just gonna move everybody to another room. Everybody should be in there now. Okay.
All right, at this time, the defendant is going to receive $1,000 split bond. It'll be a $500 surety bond for count one, a $500 signature bond for count two, and he needs to stay away from that MARTA station. What was the address of the MARTA station, Ms. Backus? And you're muted.
It looks like the address was 250 Brotherton Street Southwest in Atlanta.
All right, and he cannot return to that location. He's have no alcohol, drugs, or weapons. All right, Mr. Sanders, don't go back to that MARTA station.
Yes, ma'am.
All right, anything further from either party?
Nothing further, Your Honor.
No, Judge.
All right, best of luck to you, Mr. Sanders. Who do we have next?
I'm sorry, it's Katrina again. I'm just trying to clarify the bond because it's kind of,
500, count one, 500, count two. Count two will be a signature bond through the jail.
okay, that's what I need to say, SOB, but I didn't know what to do.
Position number 20, courtroom 3.
All right, thank you.
All right, good afternoon. Are you Demica Veazey? Are you?
Yes.
All right, Ms. Veazey, your case is 22 CR 005235Y, in which you're charged with simple battery with the offense date of August the 5th of 2022. Do you understand your constitutional rights?
Yes.
All right, Ms. Harrison.
Second arrest, first arrest was January of 2001 for robbery in Hapeville, Georgia. That arrest was dead docket. Nothing further.
All right, thank you. Ms. Backus?
Yes, Your Honor. This incident occurred yesterday, August 5th. The defendant was in an altercation with the victim, Miss LaToya Carter. It was said that the total facts are a little foggy, Your Honor, but it was said that during the altercation, the defendant snatched Miss Carter's chain from her neck and physically wrestled her to the ground. We are aware that it is a second arrest. Let's see, hold on one second. I'm trying to see what the recommendation was. Give me 1 second. Your Honor. Okay, here we are. Got it. My apologies. We are recommending a $1,500 surety. No further contact with LaToya Carter. 1 day anger awareness. No alcohol, drugs, or weapons. Nothing further.
All right. I am going to sound for Ms. Carter. Ms. Carter, if you're present on this Zoom conference and wish to be heard, this is your opportunity to do so. All right, hearing none, Ms. Jenks.
Thank you, Judge. Miss Veazey is a 38-year-old woman. She did complete high school, Judge. She actually just went through the Atlanta Public School orientation to work in the cafeteria at Crim High School. She is supposed to report on this Monday, August 8th. Miss Carter is actually Miss Veazey's sister who lives with Miss Veazey in her apartment. So this apartment lease is solely in Miss Veazey's name. It sounds like what the issue was is that basically Miss Veazey was saying that she was going to cut the Wi-Fi because her sister would not pay the $10 per month for the Wi-Fi. And when Miss Veazey went to cut the Wi-Fi to disconnect it, Miss Carter actually was the first one to grab Miss Veazey. So this was a dispute over the Wi-Fi. I'm guessing that fast forward an immunity motion will be will be filed in this case in division. As you heard from pretrial, this is her second arrest. The one is very, very old and was dead docketed. We are asking your honor to allow Miss Veazey a signature bond through pretrial.
All right, thank you.
Or the jail.
Ms.
Yes,
Backus,
Your
let me clarify these stay away locations. What was the stay away location?
3-3. Oh, Your Honor, I don't believe I asked for a stay away on
state
this. It would only be a stay away if that is the residence that and she said they're roommates, but one person's on the lease. The address is 330 Auburn Point Drive Southeast in Atlanta. I'll defer.
All right. And the state
Judge,
is
just to be
requesting
clear, the lease for that address is solely under Miss Veazey's name.
I understand that. And so the state is not requesting a stay away?
If the defendant or if the victim, Miss Latoya Carter, is still residing at that residence, yes, we are.
All right.
Yes.
I know you'd object to that, Ms. Jenks. I understand. Duly
I do,
noted.
Judge.
Duly noted. All right, at this time, Ms. Veazey is gonna receive a $3,000 signature bond through pretrial services. She is to have no further contact with the alleged victim, last name Carter. She can return to her home one time with a member of law enforcement to ascertain whether or not the alleged victim is there. If the victim is still residing there, she must stay away from that location. If the victim no longer resides there, she can return to that home. She is to have no weapons, drugs, or alcohol as the condition of this bond. And I believe that addresses all pertinent facts here. Is there
Judge, I have
anything
one
further?
question.
Yeah.
Yeah, I mean, has the state actually spoken to Ms. Carter in this case? Because if not, I'm asking that there would not be a no further contact order put in place.
And we have not in the states.
It doesn't, my ruling will stand. Ms. Carter is not here today to make a statement. Ms. Jenks, if you wish to try to get her onto the Zoom conference before we finish, I doubt that's possible. I would hear from the victim, but at this time, the ruling will stand as is. All right, best of luck to you, Ms. Veazey. Who do we have next?
Position 6, Fisher.
All right, good afternoon, Mr. Fisher. Your case number is 22 CR 0052228J, in which you're charged with 1 count of simple battery with the offense date of August the 5th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Harrison.
Karen Cycles, last arrest, June of 2019, for driving while license suspended or revoked. Record indicates an open case pending for criminal trespass. Odyssey indicates it's a bind over case, 21 MAGC 05277. 2019 felony conviction for theft by receiving stolen property. A 2016 criminal trespass misdemeanor conviction. He has 3 additional convictions outside the 10-year period. Nothing further to add.
Thank you. Ms. Francis?
Yes, Judge. The state is recommending a $3,500 surety bond, a stay away from 1191 Metropolitan Parkway Southwest, no further contact with the victim, Charson Green, that's CHARSAN, Green, normal spelling, an anger management class, and no drugs, alcohol, or weapons while on bond. Judge, in this case, the defendant pushed the victim with her hands during a dispute on 2 different occasions. The officer did note that there was alcohol coming from the defendant while he was on scene. The state's only concern is this defendant reoffending. This is his first family violence charge, so the state will defer to Your Honor.
All right, thank you. Mr. Howard?
Yes, Judge. Mr. Fisher, Judge, has been living in Georgia for more than 24 years. Yes, he's 40 years old. He works full-time for Demolition Brothers. He's been on that job for about 8 years working. He does carpentry and other work as part of his employment. He does have 4 minor children, or actually 4 minor children that he helps to support that are not at issue in this case. But he's certainly concerned about being able to maintain his stable employment. He tells me the version of events that he gave me is much different from that the state has provided. And of course, we'll have an opportunity to address it more fully at a later hearing, but it's suffice it to say he indicates that he was hit in the face with a beer can by Ms. Green in this case, who he says was drinking, as well as a microphone. And he tells me that he is the one that actually called the police to the scene. So, Judge, given his lack of violent history and a lack of failure to appears or anything to indicate he would not return to court to answer these charges, we'd ask the court to consider a signature bond in this case.
All right, I'm going to sound for Ms. Green first. Ms. Green, if you're present on this Zoom conference and wish to be heard, this is your opportunity to do so.
Judge, if I may, before you proceed. Judge, the facts that we reiterated came directly from the police report, and the cops did speak with the defendant. So if that was what happened to him, I would like to think that he would have told them at that time.
Okay, thank you. At this time, defendant will receive a $4,000 signature bond through pretrial services. He is to stay away from the incident location on Metropolitan Parkway and have no contact with Ms. Green. He is to have no weapons, drugs, or alcohol as a condition of that signature bond. Is there anything further from either the state or the defense?
Nothing further. Thank you, Judge.
All right, best of luck to you, sir. Who do we have next?
I'm sorry, Judge, was it through pretrial or through the jail?
Pretrial.
Okay.
Pretrial.
Position 9.
Hey, Blunt, before we do position 9, let me do position 8.
Okay, that's fine. Go ahead.
All right, we have position 8, Byron Jones. Mr. Jones, your case is 22 CR 005231A, in which you're charged with public drunkenness with the offense date of August the 5th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have the right to an attorney at this proceeding today. Do you understand your constitutional rights?
Yes, sir.
All right, I also am going to inform you that we're broadcasting this over the internet and it's a live stream. It's also being recorded. That means any member of the public can watch this proceeding. Ms. Harrison, can I have the history, please?
This is position 8.
Yes, Byron Jones, position 8.
38 cycles, last arrest July of this year for disorderly conduct in Dunwoody, Georgia. No disposition listed on that arrest. Record indicates 3 failure to appear within the past 10 years. He has, one moment. He has 10 prior convictions for criminal trespass between 2015 and 2019. A 2013 theft by shoplifting, and a 2011 theft of lost or mislaid property. Nothing further to add.
Thank you, Ms. Harrison. Ms. Francis?
Can you hear me, Judge?
I can, yes, Ms. Francis, please proceed.
Yes, Judge. We have a plea recommendation, Judge, of 12 months to serve 2 days, credit for time served, and we're doing a balance suspended.
Oh, that's the plea offer. All right, what is your bond recommendation?
The bond recommendation is $1,000 surety bond that I think it's set at $1,000 surety bond, and we agree to remain as set. Also, a stay away from the 3 locations involved in this incident. The first location is 10490 Alpharetta Highway. The second is 10518 Alpharetta Highway. And the third is 10630 A as in Apple, Alpharetta Highway, and no drugs, alcohol, or weapons while on bond, specifically alcohol.
All right, Mr. Howard, there is a plea offer on the record. I understand the public defender's office positions. Would you like to speak to your client to see if he would like to take that plea pro se?
No, Judge, for 2 reasons. One, that if the state does have a plea offer, those need to be communicated prior to court. I mean, so that we'll have an opportunity to discuss even a plea offer at some point prior to court. But in spite of that, the second issue, Judge, no, I don't believe that Mr. Jones is in a position to entertain a plea today based on my discussions with him. It was difficult to get the information that I need to even argue bond. I do know that he's lived in Georgia for more than 20 years. According to, he gave me an address that he's lived at during that time. But I think given the level of communication that I had with him, I don't believe he could, if he wanted to, enter one today. It's just, yeah, it's not appropriate. I don't believe for him specifically to enter a plea. He even at one point wasn't going to come to court, and I was going to waive his appearance, and then he was kind of waffling about it. But yeah, based on my interaction and even, yeah, Judge, I don't believe he can entertain that today.
Before we, can I be placed in a very brief breakout,
Yes,
please?
yes, let's do that.
Please put me in breakout room. Or let's see if we can all go back to the other breakout room we were in.
Yeah, y'all should go back to the one y'all were in.
I'm gonna join that other breakout room.
Yeah, and I just have to add Mr. Howard. No, Mr. Howard's in there. He just have to join.
Just hit join. Okay.
Yeah, just hit join. Anybody who was in there, just hit join. That it keeps me creating another room. So those who want to join, is the last one can join.
I don't see join, Miss Lewis, on my
Do
screen.
not, you're in there, since McKitchen McCutcheon, it has you in room 2. You don't see it says join?
No, I don't see where it says join.
Oh.
Nope.
I'll have to move you
Go
out.
to the 4 little squares, Michelle, where it says breakout rooms, and put your cursor over it, and then it'll pop up at the bottom next to.
Oh, at the very
between
bottom. Oh, did I?
Live transcript and reactions between those two.
Okay. Join breakout room. Okay.
Yeah.
Thank you. I see it.
Thank you. Appreciate that, y'all. Thank you, Miss Jinx. Hi, Miss Harris.
Hey, how are you?
I'm here.
It's a rough Saturday.
It's a rough Saturday. You're right about that.
All right, at this time, the defendant is going to receive $1,000 surety bond. He must stay away from all 3 incident locations on Alpharetta Highway and have no weapons, drugs, or alcohol as a condition of that surety bond. He will be reset to the SAP calendar on the 18th, whereby that plea offer can be reconsidered. Best of luck to you, sir. All right, who do we have next?
Position number 9.
All right, good afternoon. Your case number is 22 CR 005230G, and what you're charged with 1 count of violating a family violence order and 1 count of simple assault with the offense date of August the 5th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Harrison, please.
Second arrest, first arrest was March of this year for simple assault and obstructing or hindering person making emergency telephone call in Fulton County. That is an open case, 22 CP 207065. Nothing further to add.
All right, thank you. Ms. Francis, your case.
Yes, Judge. This incident involved a case where the defendant went to the victim's home and was knocking on the door violently and throwing stones or rocks at her bedroom window. The events took place at approximately 2:50 a.m. in the morning, and there is a family violence order in place at the time when this incident occurred. The state is recommending a $3,000 surety bond on the violation of the family violence order and a $3,000 surety on the simple assault family violence for a total of $6,000 surety. A stay away from 3440 Boulder Park Drive Southwest. No further contact with the victim, Atlanta Ludy, that's Ludy for her last name, and Atlanta normal spelling, anger management class, and no drugs, alcohol, or weapons while on bond. Judge, this defendant does obviously pose a significant threat to this victim based on the fact that there was an order in place that he violated, and at a time when most people are sleeping in their beds at night. So the state feels like the victim is in danger based on these allegations. We do believe that under the circumstances, the $6,000 surety bond is appropriate.
All right, thank you. Mr. Howard?
Yes, Judge. Mr. Luty is 25 years old. He has been living in Georgia for 2 years. He actually attended Florida Atlantic University for a period of time where he studied courses in computers. Judge, he works full-time for Junk King as a trash removal company that it works the sites, goes to homes, and takes away when the houses are being renovated and things of that nature. He's been doing that for the past 10 months. And in addition to that, he also works doing landscaping and for a moving company and does car detailing. He does a number of things to try to be able to provide for the 2 minor children that he shares with his wife, Miss Atlanta Luty. They have a 10-month-old and a 1-week-old child, Judge. So there's a very a child that was just born that's related to this case as well. And Judge, these cases can be difficult in the sense that the court issues an order, but however, it does not apply to both parties. And obviously the other party can make the decision to reach out and to continuously try to contact his wife continuously tries to contact him in relation to the children and in relation to other things that one would understand he would need to know about. But yet there's an order which says they can't have any contact, even while she has children which are weeks and months old. So Judge, he does recognize that he cannot have any contact with Ms. Luty, and he does live at a different address, which he has since March, since the order was issued on 75 Mendale Drive is where he currently resides. And he certainly would not have a problem continuing to stay away and to have no contact with Ms. Luty. However, he is the sole financial provider for the household, so he wants to continue to be able to work, obviously, Judge, so that he can continue to do that. That's why he's taking on extra jobs to make sure that the household has what it needs, even though he's not living there, even though he still loves his children and cares about his wife and wants to make sure that the money is there, even if he can't physically be there. So Judge, outside of there, on one case, he really doesn't have much for history at all, if any. We would ask the court to take that into account and allow him to be considered for a signature bond. On the alternative, we would certainly ask for a much lower surety bond so that he can return to work, so that he can continue to provide for himself, 2 households really, and his children. So we would ask the court to consider that.
All right,
Judge,
thank you.
I'm sorry, Judge, may I?
Very briefly, Ms. Francis. Go
Yes,
ahead.
Judge. I just want to point out that this victim is the same victim in the other case. And the fact that defense attorney did also state that this defendant is just now residing for 2 years in Atlanta, which means he's from another state.
All right, thank you. At this time, the defendant is going to receive a $2,500 surety bond. Count 1, $1,500, count 2, $1,000 for the total of the $2,500. And he's to comply with that family violence order. He is to have no contact with Ms. Luty and stay away from that address and have no alcohol, drugs, or weapons as a condition.
Judge, will the court consider a third-party transfer if that's able to be?
Yes, and a third-party transfer of the child, as long as that's not inconsistent with the order that's already in place.
Absolutely. Thank you, Judge.
All right.
All right.
Best of luck to you, sir. What do we have next?
Position 10.
All right. Good afternoon. I'm Judge Melanie Williams. Will you please pronounce your name for me?
Maruzak.
Marzak. Mr. Marzak, your case is 22 CR 005232Y. And once you're charged with battery family violence with the offense date of August the 5th. Do you understand your constitutional rights?
Yes, I do.
All right. Ms. Harrison.
Yes, second arrest. First arrest was January of 2000 for driving while license suspended or revoked in Lawrence, Georgia. That was a conviction. Nothing further, Judge.
Thank you. Ms. Francis.
Yes, Judge. I also have one out of New York. I'm not sure if the trial has that. Okay, so Your Honor, this was an altercation between a husband and wife. And during the argument between both of them, the defendant struck his wife, the victim, in the face twice with a closed fist based on the information gathered by the police officer, When they got there, she had a bloody lip, and it was obvious by the officer's narrative in his report that her face had visible signs of being recently struck because her face was swollen. The officer did note that there was an overwhelming odor of alcohol emitting from the defendant's breath as he spoke, and that his behavior was unruly. The state is recommending a 5,000 surety bond, a stay away from 10865 Indian Village Drive in Johns Creek. No further contact with the victim, who is Wona, that's Wona. Her last name is Kogout, Kogout, and anger management class, no drugs, alcohol, or weapons while on bond. And Judge, I just want to point out that the defendant has two cycles out of 2 states, New York and Georgia, and is a multi-state offender, so is a flight risk. And because of these facts, as well as the facts alleged in the incident, we're making the recommendation.
Is that the correct victim's name? I feel like we said that.
Yes, the arrest.
Yes, Judge.
The New York arrest was in 1992, and it was a DUI, and it was an infraction.
Okay. I just had something similar for the victim we listed in position 21.
Judge, I'm sorry, Judge. I think that was an error on my part that I corrected.
All right. Just wanted to clarify. All right, Mr. Howard.
Yes, Judge. Mr. Marsack is 55 years old. He has significant ties to the community. He's lived in Georgia for more than 27 years. He's lived at this address, 22 years, I apologize. And he lived at the 10865 Indian Village address for 21 years. He also is the pastor of Ukrainian Orthodox Church in Cumming. So he certainly has every intention of returning to court to answer these charges. The court noted they are married. He disputes the nature of some of these allegations. He tells me that there was alcohol consumption involved, actually by both parties. And he certainly wants the opportunity, once he is released, to address the charges more fully. He will not qualify for our services after today. But Judge, given he only has a DUI from many, many years ago, he certainly intends to return to court. And it doesn't appear, he would be any type of a flight risk or any type of a risk to commit additional felonies. We'd ask the court to consider a signature bond in this case. I believe it was recommended through pretrial.
All right, at this time, the defendant will receive a $4,500 signature bond through pretrial services. He is to stay away from the address on Indian Village Drive as a condition of this bond and have no contact with the alleged victim. In this case, he is to have no alcohol, drugs, or weapons at this time, and his case will be revisited at a later date since he's being reset for this.
Okay.
And he could have a one-time.
Yes, one-time escort.
One time, he can return one time with a member of law enforcement to get any items during the pendency of this case. All right, anything further from either party?
No, Judge. Thank you.
Thank you.
All right, best of luck to you, sir. Who do we have next?
Position 11.
All right, good afternoon, Mr. Moffitt. Your case is 22 CR 005233F, in which you are charged with simple battery, family violence, with the offense date of June the 8th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right. Ms. Harrison?
13 cycles, last arrest, April of this year, for driving without a valid license, fleeing or attempting to elude police officers in Fulton County. Record indicates that's an open case pending, 22 TR 030401. Record indicates a 2021 conviction for possession of firearm by convicted felon, given false name. 2011 robbery by snatching, 2010 robbery, and a 2012 robbery by force, possession of firearm by convicted felon, and possession of firearm during the commission of a felony. Nothing further to add.
Thank you. All right. Ms. Backus.
Yes, Your Honor. The state is recommending on the simple battery, $3,000 surety bond, no further contact with the victim, Joshuna Perkins. That is spelled Joshuna, Perkins common spelling. A stay away from the incident location at 3042 Middleton Road, apartment 407. A one-day anger awareness course and no alcohol, drugs, or weapons while out on bond. Your Honor, this incident occurred on June 8th, 2022. APD officers responded to 3042 Middleton Road, apartment 407, in reference to a dispute. And upon arrival, an officer spoke with the victim, Ms. Joshuna Perkins, who advised that her husband, the defendant, attacked her. Ms. Perkins said that the dispute began over a Cash App card, and that he started yelling in front of her children. Ms. Perkins said that she asked the defendant to leave because he had been violent with her in the past. But after asking him to leave, the defendant punched her in the head and face several times. It looks like 20 days later, the officer reached out on June 28th. He reached out to Ms. Perkins, who stated that there was a misunderstanding between her and the defendant, and that they were going to counseling. But she said that they had gotten into a physical fight and that the defendant was the one who started the incident. And she confirmed that he did strike her in the head, and said that he has an anger problem. Your Honor, we feel as though the surety bond is more than appropriate. As the victim herself said, that this is a cycle for them. He's done this before. She was fearful at the time. Yes, she said thereafter it was a misunderstanding, but we're well aware of how the cycles of violence go. And so we have concern for this victim. We also have concern about this defendant's criminal history, and the likelihood of his reoffense, seeing as how he had a 2021 conviction. He also had for April 2022, an open case, as pretrial stated, Your Honor. And so because we're worried about the risk of reoffense, we feel that that $3,000 surety is more than appropriate. Nothing further.
Thank you, Ms. Backus. Mr. Howard?
Yes, Judge. Mr. Moffitt is 30 years old. He has been living in Georgia for more than 17 years. He attended Miller Grove High School right in the metro Atlanta area. He currently works for CKS, which is a warehouse company over on Fulton Industrial, where they load trucks. He works full-time there, 7 to 4. He's also beginning a program that they offer for a trade school where he'll be trained to do construction work through classes that they offer for 6 months, that he believes that will allow him to have greater opportunities for employment to support his 2 children, as well as he indicates that he is still legally married to Ms. Perkins. Judge, he disputes the allegations in this case in terms of how things happened. Suffice it to say, we'll be able to address that at a later time. But he tells me he attempted to leave the location, and Ms. Perkins, in an attempt to prevent him from leaving, just kept pulling and grabbing, but he denies punching her or hitting her, as she claimed to the officers on the scene. Judge, I didn't see any family violence history. I did note that he has a conviction in 2021, and there was an arrest back in earlier that he finished the sentence for, I believe, and the charge may have been from earlier in the 2000s, and he was released in 2017. But since that time, the charge, he's only had 1 arrest and conviction, and it was not a family violence charge or anything related to any allegations of violence with his wife. He would like the court to consider him for a signature bond in this case. In the alternative, we'd ask for a low good bond.
All right, thank you. At this time, defendant is going to receive a $2,500 surety bond. He is to have no further contact with the alleged victim and stay away from the incident location on Middleton Drive. He can return 1 time with a member of law enforcement to get any items, and he is to have no weapons, drugs, or alcohol as a condition.
All right, thank you, Judge.
Thank you, Your Honor.
All right, best of luck to you, sir. We're still, I guess the only position we have left is position 1. Is that correct? Mr. Billings?
He indicated.
He's a reset.
Oh, he's a reset. So is that complete the entire calendar?
So we have Mr. Dalton, but he wasn't added on the calendar.
Yes, and I've been talking in the chat with Miss McCutcheon about that case. Her response is along the lines of what I thought might be the case. It appears, Judge, that he had a felony first appearance on the 4th for an aggravated assault. A $10,000 surety bond was set in that case, which his family posted. However, there are 2 other misdemeanor charges. They're sequential warrants, so I don't know why they wouldn't have been handled at the same time, but the misdemeanor charges appear to be the exact same incident. But because they're misdemeanors, I mean, I don't know why they weren't handled on felony first appearance, and I believe Ms. McCutcheon was wondering the same thing. So I was hoping there was something we could do to address the misdemeanor warrants. Since his family's already posted bond on the others, I was hoping we could do something where even, maybe a signature bond through the jail on those, knowing that he had to post a bond on this case already. But for whatever reason, those 2 battery warrants were not dealt with in felony first appearance. Ms. McCutcheon, do you have it? Do you know of anything else other than related to that? Yeah.
No, Judge, and I have been conversing with Mr. Howard in the chat. It's apparent to me, I would make an educated guess that they are related because, as he said, they're consecutive warrant numbers, same arresting officer, same incident date. They did not come to us today on the jail. I thought perhaps they've been separated, but they did not come to us on the misdemeanor jail pull sheet. They seem to be related to the felony, which means they're related to that CP case number, which means it's the DA's case. And so as such, I don't feel that our office has the authority to negotiate on behalf of the state or to represent the state in a bond matter.
I'm inclined to agree. It's unfortunate though that there's nothing else we could do. Are there any other dynamic solutions? Ms. Lewis, you look confused. Do you have any other dynamic solutions or suggestions? I'm inclined to agree with Ms. McCutcheon. But if they are misdemeanors, will they eventually be sent back to us for further? I guess that would be my question. Will this work eventually end up in our lap, Ms. McCutcheon, or will it remain with the DA?
Well, that's what I'm wondering, because he's in a no bond status on both the misdemeanors. For some reason, it's like he's booked in on all 3 on the same jailing booking, but they did not address the misdemeanors. But as I said, it's the same officer, arresting officer, and the same incident date, which would make me think they're related. The other issue is, Judge, I cannot see the warrants themselves. I can see the felony warrant, but I cannot see the actual warrant for the misdemeanor. So I do not know the allegations in those.
Okay, so it appears that for now, it's not before any of us.
Correct.
And there's not.
Number.
It's 211. The booking number is 2211437.
I don't want him to get lost in the system, though. That is one of my concerns as well. Mr. Howard, you have a thought? You're muted. We can't hear you, Mr. Howard.
Thank you, Mr. Howard. Your auto went out. Your auto went out. You may have to relog back on because your auto went out. I don't see it showing up. The little microphone icon.
And I don't know why those aren't uploaded. Those warrants themselves are not uploaded into the system either. Unless you can see them, Ms. Lewis, I could not.
I can see the warrant, the EW numbers.
Right, but the document itself has not been uploaded.
Yeah, that's it. That's all I can see too.
They added it later on. It wasn't added the same day. So what the jail needs to do is set him up for court for a felony so that he can go handle that in felony. So I'll call the jail and let them know to set him up for felony.
All right, thank you. Unfortunately, sir, there's nothing that any of us can do today regarding these 2 cases still holding you in the Fulton County Jail. So your case will be reset to a later day where a felony judge will give you an appearance there.
Mr. Howard,
right.
back on right now, Judge. Hold on one second. You may have to repeat.
Can you all hear me now?
Stand back on. Yeah, we can hear you now, sir.
Yes, we can hear you.
And I was saying, Ms. McCutcheon, I'm able to actually see the misdemeanor warrants. And I think I just got it. Well, it was actually in the jail paperwork. But there's a misdemeanor warrant for battery, substantial physical harm.
Oh, you can see it now?
I can see it too, Ms. McCutcheon.
Oh, okay.
Yes.
Because before I could not see the substance of the warrant. But again,
it's still a felony case.
It's a felony case. That's the issue.
There's nothing we can do, Mr.
Right.
Howard. I appreciate, if I could, I would but because it has a felony number, I don't believe any of us can address it today.
And yeah, because obviously he runs a company, Judge, and he's
I
yeah, but I know
understand.
I
There's
thought this
nothing
might be
I
the
can
answer,
do.
but I didn't want. I was hoping
It's still
this
with
would
the
be something
DA's
else.
office, so he'll be reset to, I guess, a felony calendar on Monday, unfortunately.
On Monday.
All right, I believe that completes our entire
He was
calendar.
scheduled for today for felony court. He didn't go to felony first appearance.
He did.
Apparently,
Well, no.
but they didn't catch these two apparently.
Yeah, I
No.
think he went on the
Can you
4th.
reset him?
He went on,
originally.
yes, he didn't go today. I don't know
But
why but apparently you said the misdemeanors were added subsequently, and so I don't know why he was not brought back before the felony court.
Seems like he should have gone today to felony. I don't know why that didn't happen.
It seems that he went, but these two charges weren't addressed. Is that what happened?
That's what it sounds like.
It sounds like he went, but no one caught these.
Mrs. Dalton, did you go to court today?
No, I went on Thursday.
He went on Thursday
Okay.
and he got a $10,000 bond on the aggravated.
I got a business to run. I got 30 employees. I need some
Yeah.
back.
I don't know if there's anything else we could do. If the case is still with the DA, but, well, no, I don't, I mean, I'm still open. If you can think of something else, I don't think there's anything we can do at this point.
Ms. McCutcheon, could the state accuse it and transfer it so that we
Well-
can address the bond and then just transfer it?
Well, because it hasn't come to us, we can't even initiate it because we don't have the actual warrants to see the substance. We'd have to actually, the warrants we would have to be able to pull the warrants from the jail in order to see what's the allegation, the actual warrant itself. And I mean, but in order to initiate it, it hasn't been sent to us. So, and because it's connected to that CP case, of course, the issue with that is we would not want to resolve or deal with that case in state court because then it affects the felony, because we know that they are related.
Okay, well, and then we don't even
They're
have the
gonna set
authority
him
to
for court
reset.
for
They're
Monday.
gonna reset him. He'll be reset to
He was
felony on
supposed-
Monday.
Yeah, he was supposed to go to felony court today for those two, but for some reason he didn't go. So they're gonna reset him for Monday for felony court so they can handle those misdemeanor charges.
Because they put him on the misdemeanor pool sheet, that's why. They didn't put him on the felony pool sheet.
No, he's not on misdemeanor.
He
pool-
was not
wasn't
on our sheet.
Misdemeanor pool sheet.
Yeah.
He
Yeah,
was
he
on
wasn't
the
on our
misdemeanor
sheet.
pool sheet on our jail side, yes, he was.
He
That's how
must
we know how
because
to
he
do
must
it.
have been on somebody's pull sheet because he's sitting there. So that something happened. The problem is we can't do anything now. I think we all agree that that's the case. So he'll be reset to Monday's felony. So unfortunately. All right. I believe that completes the entire calendar. Courtroom 3 can be excused. Ms. Lewis, will you review the calendar for us?
Yes, ma'am, I can do that.
Thank you.
Okay, please note that the reset date for the SAP counter is August the 18th. Position number 1 is going to be reset to the next SEA counter from understanding. Was that a medical reset? I don't understand why they didn't.
It was
bring
at
it
his
out.
request, so just defense reset till Monday.
Okay, Monday SEA counter, which is
Yes.
August 8th. Okay, thank you. Position number 2 is the 1,500 surety bond. Reset for SAP. Position number 3 is a $3,000 SOB through pretrial, reset further notice. Position number 4 is a $2,000 surety bond, reset for SAP. Position number 5 is a $500 SOB through the jail, reset further notice. We had a private attorney on assigned to that case. Position number 6 is a $4,000 SOB through pretrial, reset further notice. Position number 7 is a $1,000 surety bond, reset for SAP. Position number 8 is a $1,000 surety bond, reset for SAP. Position number 9 is a total of a $2,500 surety bond, reset for SAP. Position number 10 is a $4,500 SOB through pretrial, reset further notice. Position number 11 is a $2,500 surety bond, reset for SAP. Position number 12 is a $1,500 surety bond, reset for SAP. Position number 13 is reset for the next SEA counter for August the 8th, needing Spanish interpreter. Position number 14 is a $5,000 SOB through pretrial. We set further notice. Position, I said 14, yeah. Position 15 is a $2,500 surety bond. We set for SAP. Position number 16 is a $2,000 surety bond. We set for SAP. Position number 17 is a $1,000 split bond. We set for SAP. Position number 18 is a $1,500 SOB through the jail. We set for the notice. Position number 19 is a $2,000 surety bond. We set for SAP. Position number 20 is a $3,000 SOB through pretrial. We set for the notice. Position 21 is a $2,000 surety bond. We set for SAP. Any questions or concerns or comments?
Ms. Lewis?
Yes, Your Honor. Can we clarify on position 14, I believe it was?
I have a $5,000 SOB through pretrial.
That's what I have.
Is that not what you have, Ms. Backus?
Hold on, let me make sure that's the right case. Oh, no, that's not it. And it can't be this one. It's gotta be, oh, no, I'm sorry. It's position 12. Can we clarify on that, what it was?
It was 500 each charge for a 1,500 total.
What was it, signature or surety?
It was surety.
Okay.
And I ordered a BHET as well.
Thank you.
And who will be sending that over?
Can you make sure you send the finished calendar to Cynthia Foster at the jail? They did not receive anything this morning for the calendar.
I'm not understand. You're talking about the actual calendar for today?
Yes, the SCA calendar.
Oh, they did not receive the copy. Oh.
That's interesting.
And they just called me to make sure you can please send the finished calendar so they're not there all night.
Yeah, I'll make sure they get it. I don't know what happened. Whoever sent it out, the clerk sent it out this morning, so I don't know what happened with that. But I just I was gonna clarify something. Yeah, just a train of thought. I said, who's gonna send over the MEHT? Whose office is gonna be responsible for getting
What? I'm sorry, what is that?
What position was that?
Number 12, y'all requesting an MHET.
No, not MH, a BH. There's a formal order required for the BH. That's really just a social worker visit. He is my, he's a frequent flyer there at the jail. And we had some issues with him on Thursday, on what was it, Thursday. I just want a social worker to go visit him. I believe the last thing he said to us was some derogatory terms about all of our well-being, and because he had nowhere to live. So I just wanted to make sure that if he does make bond, that there's somebody that's going to go see him. I don't know if we have to do a formal order, Katrina, for the social worker.
It's just a visit from the social worker.
Yes.
Oh, okay. All right.
And lastly, Mr. Howard, just to let you know, I did reach out to one of the deputies, one of my colleagues, former colleagues in the DA's office. She's one of the deputies over the intake. He'll just have to come on the felony calendar Monday because she doesn't know anything about the case. She's not willing to consent to any type of a bond. And of course, I don't have the authority to. I was hoping maybe she would jump on the Zoom, but unfortunately, she doesn't know enough about the case to make that determination now.
Right. Thank you.
And of course, because it's related to a felony aggravated assault.
Right.
Yeah.
Thank you.
All right. Hearing no further comments, changes, corrections, or questions. Today was quite interesting. I was very proud of each of you. We will be in recess until Monday, August 8th, at which time Judge Morrow will be presiding. Everyone take care. Enjoy the rest of the weekend. Please send all paperwork to Katrina so that she can go home in a timely manner.
Thank
All right.
you, Your Honor.
Thank you, Judge. Nice to see you.